Today we will discuss this State Bank of India versus Chander Kalani case, and this case is on the basis of section 43 capital A, where Mr. Chander Kalani, who was the complainant before the adjudicating officer of the Maharashtra, demanded for the compensation under section 43 capital A. That means that the State Bank of India was negligent as per the section 43 capital A. Now, to understand that what is section 43 capital A and its scope, you have to read section 43. Section 43 you can divide into four parts, or you can say four component, four ingredients. One has to prove and one want to take the benefit of section 43 and want to held any entity as a negligent or liable for and demand for compensation. The first one is the body corporate, that the entity against which you are claiming that compensation must be body corporate handling, possessing or dealing with your sensitive personal data. So body corporate handling, possessing and dealing. Here body corporate does not mean what we actually understand under jurisprudence, that any entity that have the legal personality. Here the meaning of body corporate has been extended by defining this word body corporate under the explanation in section 43 capital A, that body corporate includes company, firm, sole proprietorship or other association of individual engaged in commercial or professional activity. And so the legislature deliberately relaxing this concept, maybe because अगर कंपनी काम करता है और कंपनी नेग्लिजेंट है तो अगर हम लाइबल कहें, एंड फर्म स्ट्रिक्टली नॉट ए लीगल पर्सन, अगर फर्म के थ्रू कोई हमारा डाटा उसमें डीलिंग करता है और उसको हम कहें तो स्ट्रिक्टली अगर डेफिनेशन बॉडी कॉर्पोरेट की ऐसी ही होती तो फर्म लाइबल नहीं होती. तो इस डिफरेंस को मिटाने के लिए legislature has put that body corporate with company also include firm, sole proprietorship or any association of the person. It's not necessary that is duly incorporated, but only thing that it is in the commercial or professional capacity engaged with possessing or dealing with your data. So that is the first requirement. Then the second requirement is that data that you are claiming must be sensitive personal data or information. It's not all the data. It's not protecting all the data. Not for all data, you can apply section 43 capital A. Now, what is sensitive personal data? Again, the explanation says that sensitive personal data, common parlance we understand like the password, it may be bank detail, etc. But the detail have to be clarified so that the scope of the provision be clear. So in the explanation it was saying that the security, the sensitive personal data or the information may be as prescribed by the central government in consultation with the professional body or the association as may deem fit. And the central government has framed the rule. They have framed the rule with respect to what is the sensitive personal data, what is the the reasonable security practices and the procedure, and those rules came into framed in 2011 and they came forth in 2011. These rules are known as sensitive personal information technology reasonable security practices and procedure and sensitive personal data or the information rule 2011, or you can say in the short IT rules 2011. Under that rules the rule number 3 talking about sensitive personal data or the information. So these rules you will find in your Bayer Act if you had. If you do not have the Bayer Act, or if in your Bayer Act these rules are not there, you can simply download with the code, the repository of all central or state legislation, या वैसे भी simply through internet you can find this. Now here rule 3 of these IT rules 2011 talking about that what is sensitive personal data or information, and it says that first thing is password, then financial information such as bank account, credit card, debit card or other payment instrument detail, okay, any bank detail, your transaction, how much FD you have, how much fund you have, how much fund you have spent in the last month, etc. All these details, okay, account number, all these things. Then the physiological and mental health condition, sexual orientation, medical record and history, biometric information, our fingerprints, sometimes ear marks, maybe your that retinal that क्या कहते हैं उसको, जो आपका impression होता है. So all these things. And then on the 7th number, any detail relating to the above clauses as provided to the body corporate. So any detail relating to the above clauses as provided to the body corporate. So with the financial informations, any other information you have provided to your bank, that would also cover, okay. Similarly, in the clause 8 is any of the information received under above clauses by body corporate for process of storing. So whenever, suppose if sake of simplicity, suppose with bank account, anytime you get the transaction, it will be included in your bank detail. So this information bank received or bank store, so that would also include it, just to make its scope widen. So these are the sensitive personal data or the information. Now the third element then became that the body corporate that handling these sensitive personal data or information must be negligent. Only when the body corporate, or only when the entity to which you are asking compensation, from which you are asking compensation, is negligent, then only you will get, okay. So negligence in what part? Negligence on the part of applying reasonable security practices and or procedures. So it is the duty of every entity that is dealing with the sensitive personal data or the information to apply a reasonable security practices. But what is the reasonable security practice? That is the question, because in every time the question will be that whether this particular entity has the reasonable security practices or not. And for that, the explanation to section 43 capital A says that reasonable practices means security practices and procedure designed to protect such information from unauthorized access, damage, use, modification, disclosure or impairment as may be specified in agreement between the party. So if between the party there is information, like the same thing when we make the agreement with the guard कि भाई 4 से 5 चक्कर आप काटोगे, टॉर्च के साथ रहोगे. So similarly with these entities, some with the agreement, if someone says that you have to apply these double layer security procedure, suppose with the bank account, whenever we receive anyone want to transact the money, then with the PIN card ATM पिन के साथ में एक मोबाइल पे भी संदेश आएगा. तो इस तरह का अगर आप एग्रीमेंट के थ्रू बनाया हुआ है, तो वो प्रोसीजर फॉर स्टॉपिंग द इम्पेयरमेंट, लॉस एटसेट्रा. और इफ दैट इज नॉट देयर, then in that case it's saying that as may be specified by law for time being in force, and even if the law is not there on that point, even if there is no agreement. In case such agreement, any law, such reasonable security practice and procedure as may be prescribed by central government in consultation with the professional body. So again it's giving the power to the central government, and central government in those rules 2011 of the IT rules, rule number 8 talk about that what is the reasonable security practices or procedure. So if your entity, your body corporate have not followed those rules, have not acted according to those rules, then he will be treated as negligent. And then the fourth element is the wrongful loss or wrongful gain, or either you have suffered the wrongful loss. Wrongful loss means you are entitled to a property but you are illegally parted with that property. Wrongful gains, we take the inference from the section 23 of the Indian Penal Code. So within that understanding we have to understand कि क्या होता है. Okay, now these are the four things, that there must be a body corporate handling, possessing or dealing. Then must be sensitive personal data information. Third, it must be negligence on the part of body corporate with respect to the applying of reasonable security practices and procedure. And the fourth one is the wrongful gain or wrongful loss. Now what happened, that in this case State Bank, this case now I shared with you, State Bank of India versus Sri Chander Kalani. Okay, how this case arise, if we talk about the case history. The case is basically like the earlier case we have discussed, Sri Sanjay Dande versus ICICI and Vodafone. In that case, Sri Sanjay Dande, this thing will revise your earlier case also, that Mr. Sanjay Dande, who was the IIT, Indian Institute of Technology director and Padam Shri awardee, he had the bank account in the ICICI Bank, and the ICICI Bank had issued him the मोबाइल बैंकिंग. एक समय था मोबाइल बैंकिंग बड़ा वो करते थे, जब भी आप बैंक में जाते थे सर मोबाइल बैंकिंग ले लो. On the 6th September 2013, a particular date, वैसे date is not important, his mobile stopped proper functioning. So on the next day, through his driver, he consulted to Vodafone store, because his SIM he was using, the number he was using was the Vodafone number. Okay, so the Vodafone executive have examined the phone and said, sir, phone is okay, there is a problem in the SIM, you have to get new SIM of the same number. Then next 2 days were the holiday, and then Mr. Sanjay Kalani on the 10th, through his ID card, he got the new SIM card. When he got the new SIM card, then he got the messages that from your account 19 lakh has been siphoned, transferred to some other account. Okay, so he filed the complaint before the cyber police in the cyber cell, and then he filed the complaint for compensation under section 46 before the adjudicating officer of the Maharashtra, where he had the bank under that jurisdiction he had this particular cause of action. And bank was saying that we was not negligent, but finally I am making it short that the adjudicating officer held that bank was also negligent and Vodafone, this mobile phone was also negligent, because the what happened actually, that during the time when his SIM was not working from some other store of the Vodafone company has issued a SIM card, that SIM card to some other person on a fake ID. Okay, and by that all that thing was possible by the fraudster to complete with the bank account. And so the adjudicating officer held that that these body corporate, yes, ICICI is also body corporate, and this Vodafone is also body corporate. They are handling the information with respect to sensitive data. Yes, the this information of password and all these transactions related to bank things are sensitive personal data. On the negligent part, that whether bank and Vodafone are negligent, the negligence was on the behalf of the Vodafone was that the Vodafone has not even provided the information but the SIM card, that is the battery of the information, that is the collection of the information. They gave the whole access to the fraudster, and they have not following the reasonable security practices as followed by the central government. Central government through the TRI have different norms that they have to duly verified, and accordingly they have to give the SIM card. The SIM card was given on the fake ID. They have to verify that they are giving the SIM card that belong to that person, Mr. Sanjay Dande, to some other person on the different ID, and so there was gross negligence on part of the Vodafone. There was the negligence on part of the ICICI Bank also, because they have not this dual system of check and balance. Okay, just because they are providing mobile service, that does not mean, because something you are doing, there must be some security procedure also. And so there was the negligence on part of the KYC norm and the other rules of the RBI on behalf of the ICIC. And on the compensation, out of 18 lakh, that was quantum of the compensation adjudicatory officer has calculated, 12 लाख इम्पोज कर दिया वोडाफोन पे and 6 lakh for the ICIC. Now come to our case. What I have told, because that you better understand, because otherwise you will not get understand this case of Chander Kalani. That Mr. Chander Kalani, Sanjay Dande का तो at least mobile banking था. This Chander Kalani does not, Mr. Chander Kalani and his wife have a joint account in the State Bank of India. Okay, in the Maharashtra, Mumbai. And this person was the NRI. He was residing in the Lagos, Nigeria, in Africa. He has that bank account, many 6-7 FDs, fixed deposit. And this person, when once came to the bank branch and he got updated his passbook, he come to know that his FD was unmature or with maturity, before maturity it has been broken down, and amount is transferred to some unknown account. When he come to know, he filed the FIR in the cyber crime. Police did the investigation, and then the more facts came before us. Actually what happened, that in this whole thing, this Chander Kalani has not subscribed any mobile banking, net banking, etc. Okay, he has a registered email with the State Bank of India. Once the State Bank of India got an email, okay, email उसी का था, किसी हैकर ने उसका email access कर लिया, and from that email the communication was initiated with State Bank of India that I am so and so, and I have a medical emergency, and so I need some money, and that money has to be transferred to some other account जो उसका नहीं है, to some other account that Chander Kalani was not the owner of that account. Then this after this the bank officials say that they have to comply with RBI norm, so one A2 form has to be filled. So he said that I will submit A2 form also. So A2 form and that also handwritten sign और उसकी scan copy बैंक को भेज दी, and on that bank has transferred the money. It was actually demanded in some 40,000 pounds, and then if we calculate it in the 63 lakhs Indian rupees. Okay, now the question is that bank gave the service, bank is happy कि हमने अपने customer को perfectly service दी, and Mr. Chander Kalani complainant, he was very worried that he was not even aware, he was not even having any iota of the doubt कि some person has siphoned the money from his account, and then he saw that the bank official also actively doing that thing. Then he filed the that case before the adjudicating officer for the compensation. And the adjudicating officer has I don't want to tell you that what they have decided, but on that the appeal is there, because if I tell you then you will get the clue that what actually happened. Now it is the question before you, आपके सामने question है that whether State Bank of India is liable to pay compensation under section 43 capital A or not for the loss the customer of the State Bank of India, Mr. Chander Kalani, has suffered losses of 63 lakh rupees. Yes, anyone would like to answer this?
Yes sir, bank is liable sir.
How?
Sir, as they were negligent.
Yes, एक एक बोलो.
On their side.
What negligence? Yes, Nisu, would you like to elaborate? Negligence कैसा negligence हुआ?
So just through email, they believe that it wasn't an importer, and they believe that he was the Chander Kalani who is demanding
Good. Very good, very good, very good. But bank has replied that they are giving these services to their customer for benefit of the customer, and earlier also this person has taken some service through the email. तब तो इसने कुछ नहीं कहा, अब लॉस हो गया तो हमें कह रहा है.
But sir, bank failed in maintaining reasonable security practices. अगर वो हर बार लेता था तो इस बार आपको at least you must put a check over it कि ये वही बंदा है या नहीं, तो वो तो negligent है ना सर बैंक.
Okay. Vikash.
Sir, I have two solutions, sir. Yes, sir. Actually, I think generally what bank does in these conditions, they are actually collecting this application form in hard copy. So they are not generally, if you go to the bank, they are not entertaining such application through received by email. So that's one part actually that I think, in my opinion, that they have compromised the security. And second part, that actually whether that said mail, whether they have received, which has been registered with the bank email ID. Suppose if they are maintaining email ID respective with that individual in that record, and such if they have receiving such email ID, such kind of letter from this email ID, then they should have entertained. So I think there is an only
The email ID was same as it was registered. There is no default in that.
anomaly in that.
Yeah.
Okay.
Yes, very well you guys have say. Yes, Mr. Deepak, हमारा एक स्टूडेंट दीपक होता था, बहुत ही प्यारा सा वो कुछ. यस दीपक. चैतन्य, you also give your opinion. What you?
So join late.
Okay, no issue. चैतन्य, क्या लगता है स्टेट बैंक की नेग्लिजेंट था या नहीं था? बिकॉज नेग्लिजेंस अगर हम प्रूव करेंगे तो कंपनसेशन, बिकॉज वी हैव टू सी 4 ingredients ऑफ द सेक्शन 43 कैपिटल ए, बॉडी कॉर्पोरेट, हैंडलिंग, पोजेसिंग एंड डीलिंग. ऑन दैट आई थिंक देर इज़ नो इशू. किसी को कोई नहीं होगा भाई, स्टेट बैंक तो बॉडी कॉर्पोरेट है ही, और ये आपकी डाटा इन्फॉर्मेशन को हैंडल भी करता है, जो भी आपकी डिटेल्स है उससे रिलेटेड चीज़ें. sensitive personal data on so this telling the information and then doing all these things is the sensitive information. That is also not anything that covered under the rule 3 that relating to the your bank details, bank accounts is sensitive personal data. The third thing on the negligence, we have to clear it. Wrongful loss, yes, suffered wrongful loss and some person gained the wrongful, उसको तो सर आ गए इतने 63. So the main emphasis in this particular case is on whether the State Bank of India was negligent in implementing the reasonable security practices or procedure. Okay, and here you guys have given very good observation, very good observation. See, if you see the arguments, the arguments from the bank was that this is the official email ID registered with us, and so we had entertained it. This was not the first time that Mr. Chander Kalani was doing or requesting for something through the email. Earlier also he did. The third thing is that we have to comply with the A2 form that we have complied. On this, even on they have said that we have even made the call on the phone number registered with us of Mr. Chander Kalani, but it was not functional, and so we have even taken care about it. Mr. Chander Kalani said that yes, earlier I have requested for some service with the bank through the email, but before that I had the conversation, and in the email I have written, as per our conversation, telephonic conversation, I am requesting this. Okay. The second thing is that this phone was not functional was the sufficient ground to reject the request, that only after the confirmation through the phones I will this, and in this case it was not, so I reject the request made by the email. The third one is A2 form, and that was the scanned copy. Now see, scanned copy में आपने साइन करते हुए नहीं देखा. Signature, जो हैंड रिटन सिग्नेचर मस्ट बी विद द थर्ड पार्टी. व्हेन यू गो टू द बैंक एंड डूइंग, वो आपके सामने एक साइन और करवाते हैं, एंड दैट इज जस्ट टू शो दैट इट वाज डन बिफोर यू. Okay, so just to this was the scanned copy, and even the person, the hacker who got access of this person also can get the the sign and then paste there it. So there was also Vikas very well explain this thing. So that was also. So these were the arguments from both the party. What the adjudicating officer held? The adjudicating officer held that yes, there is the negligence, but the negligence was not only behalf of the bank. The negligence was also on the behalf of the complainant also, because yes, because the doing the banking transaction through the email is very insecure way, and that is also not, there is check and balance. Okay, now the banking sector or the RBI is also framing rules that before the clearance or this type of the thing you get the messages, in the credit card they have some other protection. The law is still developing, because every day people are facing this type of the problem. Okay, and so they said that out of that, when the the money was actually transferred to some bank account in the Britain, so police have requested for that bank account through the proper channel, और वो कुछ पैसा अभी जो वापस किसी ने निकाला नहीं था वो मिल गया. So finally held that both are liable, but the bank liability is much more, and bank as a it's such a reputed person and a body corporate has to comply with, even if the customer are suppressing, they have to follow the reasonable security practices. Then compensation was awarded as the 40 lakh. State Bank of India went into the appeal. appeal कहाँ पे जाएगा? Before the under section before the appellate tribunal. Okay, so before the appellate tribunal they went into. Earlier we had this adjudicatory officer judgment. Now we have this the appellate tribunal judgment. In the appellate tribunal, if you remember that the section 48 talking about appellate tribunal, the TDSET, the Telecom Dispute Settlement and the appellate tribunal as established under the section 14 of the TRI Act. So TDSET has passed this particular order, and this order is with you. I have just shared the screen, so it's here. Now here in this particular appeal, you will find that finally the the appellate tribunal, that is TDSAT, the appellate tribunal has dismissed the appeal and said that what is the judgment of the adjudicative official is perfectly valid. That means the bank is the negligent. Okay. Now see, in this particular case, the first para that you find Siva Kirti Singh, chairperson, is about the case that about the judgment, the jurisdictions, that how the this case was before that TDSAT. It was under section 57 read with section 48, etc. Then the second para is about the facts. A third para is also about the facts, and then there are the arguments from the both the sides, like there is the argument from this person's side on the para number 6, and argument in the then from the bank side on the para number 7, and then from the para number 16, para number 16, 17, 18, 19, 20, 21. This is the gist of the this particular case. When you read para number 16, you will find that what is the section 43 capital A, what are the requirements, what has to be proved, and then in the next para also it's about the law, and then the tribunal has applied that law in this particular judgment. So you have to read, you can mark also para number 16, para number then 17, then para number 18, then para number 19. Okay, and then para number 20, and finally the region decision in para number 21. But yes, I am reading from the para number 19 because we already have discussed the law section 43, so it's not required to again and again read it. You can read yourself 16, 17, 8 आप बाद में घर पे पढ़ लेना. Para number 19, 20, these 2-3 para I will read it. Para number 19 says that the reasonable security practices and procedure required to be implemented and maintained had to be designed to protect such information from various acts such as unauthorized access and uses. In the present case, nothing has been brought on the record by the bank to show that it has implemented and maintained the reasonable security practices. That means both sides argument has been made, but the in the civil cases, the liability or the burden of proof on the part of the complainant is preponderance of the probability. That has to be rebutted by the respondent. That means if the complainant is saying that bank is negligent, then the liability is on the bank to rebut it, and they have not proved any facts, any proof by which they are actually rebutting कि हमने तो जी ये सिक्योरिटी प्रोसीजर अप्लाई किया था. ओके, यस. So bank to show that it had implemented and maintained the reasonable security practices to protect such information from unauthorized use. Rather, the bank itself used the email received on its computer resource unauthorized without authority from the complainant for such use, for transfer of the complainant money to the another bank account. Okay, had there been a reasonable security practice and procedure in the operation, the concerned personnel could have found that the transfer through the email had not been authorized by the complainant. In fact, no safety or the security measure appear to be in place because the transfer was made even without the confirmation through the registered mobile. The fact that the complainant registered mobile was not functioning should have worked in favor, because by way of reasonable security practice, the bank, if it had the practice of confirmation through mobile phone of the account holder, ought to have rejected the transfer of the fund through the email on the valid ground that there was no confirmation available through the registered mobile of the account holder. Okay, so that we are talking about that it's showing more negligence on part of the bank, that when you have not any authorizations or you have not confirmed this thing through the phone number, So that was the valid ground. You should reject that the request made through the email number कि आपका फ़ोन काम नहीं कर रहा है, and that's why we cannot make it. Okay. The second thing is about the scan copy. It's saying that use of scanned signature on A2 form received through the email was another unauthorized and illegal use of so-called signature, which cannot have any sanctity either under general law or under IT law. And that thing even as common men also know. If there is a signature, any signed document, any photocopy of the signed document, what sanctity it has. Signature means that has to be signed properly by the pen and if possible before you. And so the getting that is also another way where they had not reasonably in the manner they have acted. Okay. Then on the para number 20, the rule 4, they are referring to the rule 2021, IT rule 2021 that I said, that the rule 4 require a body corporate to have in place a policy for privacy and disclosure of information. In present case, in spite of serious allegation of unauthorized use of data and the information relating to the complainant, the bank has failed to bring on record any material to show that it had in place a policy as required by the rule 4. Rule 8 contain provision for purpose of finding out as to when the body corporate shall be considered to have complied with the reasonable security practices and procedure. The appellant bank did not bring on record any material to show that it had complied with the provisions of reasonable security practices and the procedure in term of the rule number 8. And so finally, para number 21, that in view of the aforesaid discussion, it is found that bank was negligent in implementing and maintaining the reasonable security practices and the procedure at the relevant time, at least thereby it caused wrongful loss or complaint, and hence it was liable to pay damages by way of compensation, and held by the learned adjudicating officer all the ingredients for attracting the and applying section 43 capital A of the act are made out, and hence this account no interference is required with the impugned order. And so it's saying that maybe as general we cannot say, or we have hesitant to say that the bank is negligent, but on these account in this particular situation जहाँ पे उन्होंने ऐसे किया, surely they are negligent, and for that they are liable. So guys, finally the appeal was dismissed, and what the order has been passed was confirmed by the tribunal. So this is the fate in the there is in the America there is some security practices or the procedures that section one second. Section 909 of Electronic Fund Transfer Act of the USA dealing with consumer liability, and they say there most of the bank in the USA and in other developed nation insure their customer against the online fraud or the ATM fraud. And on the similar lines, recently in January 2014, Banking Codes and Standard Board of India unit has issued the code of banks commitment, where the customer of such fraud will be liable only up to the extent of 10,000 rupees only, and bank has to make good to the rest of the amount, but acceptance of this code by the bank is not visible. And so in the western country, in the developed country, there is much more protection given to the customer, but that is not vigilant. Even in these two cases, adjudicating officer in the Sanjay Dande case, he has expressly said that Mr. Sanjay Dande, who was the IIT director, he was the Padam Shri awarded, now also working as a national security advisor in that team, and the apathy bank has shown it's very something very shocking that adjudicating officer was observing. So guys, these are the two cases on section 43 capital A. Please go through section 43 capital A in the IT Act, then the rule 2011 information technology, reasonable security practices and procedure, and sensitive personal data rule 2011. And with these two cases, in the Pawan Duggal case you will find some other cases also, but that you can read for your understanding. As far as we talk about our examination point of view in the Delhi University, we ask strictly, we limit ourselves to make a problem based question from the facts, using the facts of the cases that has been provided. So with this, the discussion on section 43 capital A is over.